Welcome, viewers, to my review of Trust and Will, an online estate planning service. My name is Richard Land. I'm an attorney and a member of the Connecticut law firm known as Chipman, Mizuko, Emerson. This introduction is a summary of the complete detailed review which will follow. First, as a disclaimer, I'm not affiliated with Trust and Will in any way, and I'm not involved in any litigation against Trust and Will. I'm an attorney who's been involved in computerized document assembly systems since the 1980s. I've written several estate planning systems myself, and I decided to review Trust and Will merely because I'm interested in the topic. This review reflects my professional evaluation based on going through the platform and reviewing the documents it generated for me. My aim is to help viewers and clients understand what T&W offers, what it lacks, and whether it can meet their estate planning needs. I did a similar review on LegalZoom several years ago with the same intent, to provide a fair, honest, and comprehensive assessment of the platform's strengths, weaknesses, and risks. Let me start with a summary in case you don't have the 20 minutes or so to watch the full review. First, Trust and Will delivers on its promise to provide an easy way to create an estate plan and keep it up to date. However, in my opinion, its service falls short of customers' reasonable expectations that the estate plan provided will adequately address their specific needs. Second, the site offers impressive features for record keeping and document storage. While these are valuable, this review focuses on the quality, technical reliability, and substance of the estate plan and documents it creates. Third, simplicity seems to be prioritized over flexibility and depth. The interview process is rigid and narrowly focused, leaving little room for addressing unique or complex circumstances. Fourth, customer input errors are both inevitable and foreseeable, yet T&W fails to include adequate safeguards or alerts to catch and correct them. This oversight creates unnecessary risks which must be addressed for the service to be truly reliable. Fifth, the trust agreement generated during my review contained technical flaws, potentially conflicting provisions, and ambiguities. These issues could lead to unintended consequences for users. Sixth, in my opinion, it's premature and risky to introduce artificial intelligence into the estate planning process as done by T&W. In my experience, AI frequently provides inaccurate information when applied to legal research, and during my review, T&W's AI exhibited similar unreliability. Seventh, customers cannot directly edit the text of the documents prepared by T&W. Editing is limited to revisiting answers provided during the interview process, which can be frustrating and restrictive. Eighth, while T&W's fee is lower than what you would pay an experienced estate planning attorney, it's still substantial. I paid $499 for an estate planning bundle with an optional $299 for enhanced attorney access and $39 per year subscription for updates. These add-ons come with significant limitations that warrant close scrutiny before committing. Ninth, T&W's terms of service and use agreement shift all risk to the customer. If something goes wrong, the customer and their beneficiaries have little to no legal recourse against T&W, subject to arbitration provisions that are favorable to T&W. T&W explicitly accepts no responsibility for errors. 10th, here I'm going to borrow from my earlier LegalZoom review. I'm often asked, is T&W appropriate for the average Joe? It might be, but the platform lacks a process for distinguishing between customers for whom it might work and those for whom it won't. It does not adequately probe into customer circumstances or flag potential issues, which I consider a serious defect. In my experience, the so-called average Joe is rare, and this lack of deeper inquiry creates significant risks of unintended and unfortunate outcomes. Does Trust and Will have potential? T&W offers some impressive features. but I believe the risks outweigh the benefits, and potential buyers should proceed with caution. That said, the platform feels close to providing a truly useful service with acceptable levels of risk. To achieve that, however, it would need to overcome substantial challenges, including those related to the unauthorized practice of law. First, what promises does T&W make, and what were my first impressions? Trust and Will markets itself as the easiest way to create your estate plan and keep it up to date. The site promises guided navigation, affordability, state-specific customization, and support from attorneys if needed. Its platform appears polished, modern, and user-friendly. However, promises alone don't build a solid estate plan. To evaluate whether T&W lives up to its claims, I went through their process step by step as if I were a first-time user with limited legal knowledge. First, here are the facts I presented to T&W. The settler's name is Harold S. Fiction. He's married to Henrietta A. Fiction. Harold has 2 children from a former marriage, Janine and Reuben. Henrietta has a child from a former marriage whose name is Paul. Harold's wife is to receive 100% of the trust assets, except for a specific gift of baseball memorabilia to his niece, Mary. If Henrietta does not survive, 80% will go to Paul, Henrietta's son, and 20% to Janine, Harold's daughter. A trust is to be established for each of Paul and Janine, with distributions at ages 25 of 50% and age 30 at 100%. The initial trustee is Harold, the settler. The successor trustees are Henrietta and Janine, with Paul and another person named Herman Villain as backup successors. Harold is the only one doing a trust agreement, and it's not a joint trust. He is not preparing a trust agreement for Henrietta. Here's my step-by-step analysis. T&W's platform is fairly easy to navigate with clear prompts and an intuitive layout. Basic information such as naming your trust or specifying your heirs is straightforward. However, the process frequently prioritizes simplicity over substance. Critical decisions, such as choosing between a will or a trust, are presented early in the process without sufficient explanation of their implications. The platform collects essential information about family members, assets, and distribution preferences, yet it fails to ask follow-up questions about critical topics like prior marriages, stepchildren, or specific financial concerns. For instance, while the question about Harold's family situation was intended to determine whether he or his wife had children from prior marriages, it failed to delve into deeper and more nuanced issues commonly associated with blended families. There were no questions about prenuptial agreements or divorce settlements that might affect the plan, and no inquiries were made about potential financial vulnerabilities such as a child's debt or health issues or cash needs. The lack of deeper probing creates a significant risk of omissions or misunderstandings, especially for users with complex family or financial situations. While the platform's lack of deeper questioning neglects important issues, an equally significant problem is how it handles user input. When a user inevitably provides incomplete or inconsistent information, does Trust and Will do enough to catch it and raise a red flag? I experienced firsthand that it's possible to make input errors on the platform with no safeguards to flag errors. For example, I accidentally skipped over a question about spousal distributions, and the platform allowed me to proceed without any warning. As a result, the trust agreement correctly allocated 100% of the trust assets to Harold's wife by name. You can see that here. However, in language that would be difficult for a non-lawyer to spot, the document stipulated that if that beneficiary, Henrietta, did not survive me, the entire 100% intended for her would instead go to her descendants, a result entirely contrary to my intent. You can see that here. My actual intent was to leave a portion of the trust assets to my children, not 100% to my spouse's child. I acknowledge that this error arose from my mistake. I want to make that clear. It was my mistake. My mistake left a critical question unanswered. You might consider this a rare fluke, but the platform could have flagged the omission with a warning such as, "Are you sure you want to leave nothing to your spouse?" Or, "You skipped a key question. Click here to review it." Unfortunately, the platform did not provide that type of safeguard. I discovered the error only after carefully reviewing the completed documents, a process that would have been challenging for someone without a legal background. Even after identifying the issue, it took me quite a bit of time to understand why the document had been prepared incorrectly. If I had answered the question properly, the document would have made more sense. However, in this case, the lack of an error prevention mechanism suggests that similar mistakes are possible for other users. Such risks call for better precautions to ensure the platform generates documents that accurately reflect the user's wishes. As an aside, in the process, I discovered that I'm unable to correct the error by directly editing the document. In other words, apparently the document I will receive from T&W is a PDF document that cannot be easily edited. What I've described so far highlights the importance of reliable guidance throughout the process. Trust and Will does offer support features, including an AI assistant called Will-E. Will-E is designed to help users navigate challenges and provide assistance, but how effective is this support? Unfortunately, in Harold's case, the information Will-E provided about preparing a deed for his real property was incorrect for Connecticut, raising concerns about its reliability. While T&W does caution that AI-generated advice may not be accurate, the authoritative tone of Will-E's responses can mislead users into accepting its guidance without question, potentially leading to significant errors. After completing the interview process, I reviewed the trust documents generated by T&W. The T&W designers made some interesting decisions. Below are my observations. First, based on my experience with the T&W platform, its designers seem to employ a relatively rigid approach with narrowly structured options, with little effort to introduce their customers to alternative strategies tailored to their specific circumstances. For example, apparently the designers decided to default to naming the settlor, in this case Harold, as the sole trustee, without offering the option to appoint a co-trustee. This decision is significant because co-trustees can provide essential continuity during periods of incapacity or following the settlor's death, particularly in spousal or blended family situations. The designers also decided to preclude the customer from editing the documents after they're generated. This lack of flexibility, combined with limited options during the input process, creates substantial barriers to achieving a document that adequately addresses the settlor's unique needs and intentions. It also prevented me from correcting the error that I described earlier. Is this a feature or is it a problem? If you were able to edit the document yourself, perhaps T&W's designers decided you will not be able to make the types of mistakes that are common when do-it-yourselfers make changes. The documents also protect some types of assets, retirement plan assets in particular, from sharing in the estate tax burden without any guidance regarding who picks up the tax burden related to the retirement plan accounts. In the current environment of very high estate tax exemptions, estate taxes will be a problem only for the very wealthy, so maybe there is no reason for the average person to be concerned. On the other hand, exemptions go up and down as the political winds change. Failure to address such details could have significant consequences for families, particularly those with existing tensions or conflicts. Such fine points should be carefully addressed to avoid unnecessary disputes and unintended outcomes. Designing a platform like this requires balancing simplicity with flexibility. Does the design prioritize making the process easier for the designers at the expense of delivering documents that genuinely meet the customer's needs? Here's an example. In the terms of the trust for the children, the trust beneficiaries are granted a lifetime general power of appointment. In effect, such a power allows the beneficiary or the child to withdraw the entire trust at any time. This provision seemingly runs counter to the primary purpose of such trusts, which is to offer long-term management and protection of assets from the youthful impulses or potential misjudgments of a young beneficiary. Additionally, it exposes trust assets to significant risks, including claims of creditors and divorcing spouses, undermining the trust's intended protective features. My impression is that most clients, probably almost all clients, would want the trust to offer such protection and management features and would be horrified with the idea of an 18-year-old beneficiary having the power to demand all the trust assets. There may be some rationale to this choice that I don't understand. I can imagine some income tax rationales, but no rationale that's especially compelling. Here's another issue that requires comment. I'm not certain whether it's a design decision or a mistake. The terms of the trust for Harold's children state that upon the beneficiary's death, the trustee shall distribute the trust to the surviving descendants of the current beneficiary per stirpes. I believe this language introduces ambiguity because it does not clarify who must be survived. Must they survive Harold, the settlor, or must they survive the current beneficiary? Therefore, it remains uncertain when the determination of surviving descendants should be made, at Harold's death, which might occur soon after the trust is established, or much later, at the beneficiary's death. While this may seem like a fine point, in Connecticut, the jurisdiction that applies to me, there's a legal presumption favoring the earliest possible vesting of interests unless the trust explicitly provides otherwise. In this case, the trust could be interpreted as creating a vested interest in the descendants at Harold's death rather than later at the death of the trust beneficiary. Applying this presumption could lead to unintended and costly outcomes, potentially enabling litigation that challenges the assumption that vesting occurs at the trust beneficiary's death. This last example, involving the interpretation of the word surviving, highlights how seemingly minor drafting choices can have significant implications. Now, let's examine additional issues, such as conflicting provisions within the trust document that can create confusion or limit the effect of other provisions. The terms of Harold's trust include a protected beneficiary section. On one hand, as mentioned earlier, the trust gives the trust beneficiary substantial control over trust assets, including the ability to access or withdraw funds freely. On the other hand, in the protected beneficiary section of the trust, the trustee is granted broad powers to withhold distributions from protected beneficiaries, defined as a beneficiary who is unable to manage the beneficiary's own finances. I don't know how to reconcile these two provisions. If including the protected beneficiaries provision is to provide a way to protect trust assets from the claims of the beneficiary's creditors, or to preserve trust assets while qualifying the beneficiary for public assistance, in Connecticut, I doubt such provisions would accomplish such goals. Harold's trust also includes a spendthrift provision. Such a provision is designed to protect trust assets from the irresponsible spending of the beneficiary and other activities that could expose the trust assets to risk. I believe the spendthrift provision in Harold's trust is more likely rendered ineffective by the trust's other provisions, such as the lifetime general power of appointment that I just mentioned. The trust also includes a no contest provision. Such a provision typically states that if a beneficiary contests the validity of the will or trust, the beneficiary will forfeit his or her inheritance. No contest provisions are often frowned upon by the courts. In light of some of the ambiguities described above that would require court involvement to resolve, Would you want one of your intended beneficiaries to lose or be afraid of losing their inheritance merely because he or she asked the court to resolve the issue? I suspect that you would want the beneficiary to be able to make his or her case in court without fear of forfeiture. That concludes my review of the Trust and Will Estate Planning Service. I hope you found this analysis helpful and that it provides some clarity on what Trust and Will offers, as well as its limitations and potential risks. Keep in mind, estate planning is very personal and complex. While platforms like Trust and Will may offer a starting point for some, I encourage you to carefully evaluate whether their services truly meet your needs or if a more personalized approach might be better suited to your unique circumstances. Thank you for watching. If you have questions or would like to learn more about estate planning, feel free to check out the additional resources on my channel. Don't forget to like, subscribe, and share if you found the content valuable. Take care and good luck as you work on your estate plan.